All right, well, I guess let's start in. Again, we may be joined by a few others along the way. I hope we will be. And it's my pleasure to introduce John Calvert, who is coming to us from, where are you located right now, physically?
Our basement broadcasting booth, the BBB.
Okay.
So, yeah, we're
Which
in
is,
Alexandria, Virginia.
okay, you're in Alexandria at the Patent and Trademark Office. So the class has been primed for what is going to happen here in a very brief way, but I think maybe it would be good if you could start by introducing yourselves again, giving a little bit of background, and then the floor is yours.
Very good. We'll do that. I'm going to let Mindy Fleischer introduce herself. Or I'll introduce Mindy Fleischer, but I'll let her talk about herself.
Okay, great. Yeah, thanks. Hi. So I'm Mindy Fleischer. We're both officially supervisors at the Patent and Trademark Office, and we do a lot of special projects. So we have a lot of involvement with independent inventor programs and university outreach and that sort of thing. And I think between the two of us, what do we have? Like
About 40 years.
40 years. We have 40 years of experience in the office between the two of us. So we're coming to you with a lot of years of experience. And before I throw it back over to John, one thing that we really are committed to is that you get as much out of this hour as you possibly can, and we want to make sure that we do address any questions that you have about intellectual property and innovation and how to protect those things that you may have discovered. As an example, how many of you have heard of Dean Kamen? Raise your hand if you've heard of Dean Kamen. Okay, great. So one, how about the Segway, that funny looking thing you ride? Have you heard of the Segway? A couple more. Yeah, so most people have heard of the Segway. Well, Dean Kamen actually invented the Segway, and his first invention was when he was 17. It was an insulin pump. So if you're in college already and you don't have any patents, you're behind the 8 ball as far as Dean Kamen goes. So we just really want you to be thinking about those ideas you have and what to do with them once you have them.
Okay, and I'm John Calvert. And my area of expertise here at the Patent Office, besides dealing with independent inventors and universities and small businesses, happen to be in the area of textile technology. I used to tell people I worked in low-tech software. That's underwear and socks for the uninclined and the uninformed, I should say. So I've been here, as Mindy said, Mindy's been here a little bit longer than I have. I'm almost approaching 20 years, and Mindy's a little over 20 years, almost 21.
October 10th, it'll be 20 years.
So we're hanging right in there, and we'll be trying to bring you some information. And one thing I want to say before we get started into our presentation, there is a time lag of about 1 to 2 seconds because of the broadcast that's going across the internet. And so what we'll do is, we have slides that we're looking at. Once we finish the slide, and we'll try to give you a couple seconds. We'll ask a question, give you a couple seconds, and see if anybody wants to ask us anything. So be prepared. Okay?
And please do ask us questions along the way, because that'll help us steer the conversation where you want to have it go.
Okay?
Okay. So we're going to start at the very beginning, right?
Right. And it starts in 1787 when our founding fathers signed a very important document called the Constitution. And in that there is an Article 1, the very first article of the Constitution, 2 clauses, Article 1, Section 8, Clause 3, and Article 1, Section 8, Clause 8. I'm going to let Mindy talk about the second clause, Clause 8.
Okay, great. So Article 1, Section 8, Clause 8. You all don't have that in front of you, and you probably don't have it memorized. But like all the other articles of the Constitution, what it did was give Congress some powers. So that particular clause gave Congress the power to promote the progress of science and the useful arts. So that really is the foundation, and I'll read you the rest of the clause, but it's the foundation for patents and copyrights. And as it says right in the clause, the whole purpose of the patent and copyright systems in our country is to promote the progress of science and the useful arts. And Congress was to do that, according to this article, by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So the things to remember in this clause as we move forward, first again, it's authors and inventors, so copyrights and patents. And the point is that we're supposed to be promoting the progress of science and the useful arts, not stymieing the progress. And we're supposed to do that by securing for limited times, not forever, but for limited times, the exclusive right to those respective writings and discoveries. And exclusive here means the right to exclude others from using your invention or your writings. It's not the right to actually use them yourselves, and we'll talk more about that when we get to patents and copyrights. So that's Article 1, Section 8, Clause 8.
And in Article 1, Section 8, Clause 3, allows Congress to regulate commerce between the states and among the several, between the states and the nations, foreign nations, and with Indian tribes. And basically, there's nothing in there about trademarks. But commerce is commonly understood by looking at something that you're going to sell or buy. So the Lanham Act used the trademark clause or the commerce clause to attach itself to the Constitution. So they go back to Article 1, Section 8, Clause 3 in this case, and gives us a commonality with the trademark system. We'll talk more about what that means. One thing you will notice, there is nothing in there about a limited term, so you'll see how that works when we get into talking about trademarks. Any questions? Okay, we'll move on. We've already said there's three types of intellectual property protection offered through the Constitution. That is the copyrights, the patents, and the trademarks. And all three of those are statutorily based. They are under federal law, and those laws allow certain agencies to cover what is protected and how to administer the laws. And that's what happens in the copyrights and trademarks and the patent system. The other type of intellectual property that you'll run into is called trade secrets. The difference between the top three, or the first three, the copyrights, the trademarks, and the patents and the trade secrets, is trade secrets are contract law. They're under state statutes rather than a federal statute. And when we get to trade secrets, we'll talk a little bit more about how they are administered and how they affect you.
Yeah, I think something that I'd like to add on this slide that John sort of alluded to, copyrights, trademarks, and patents all are all subject to laws that are administered by a variety of federal agencies, or really by two federal agencies. Copyrights have laws that are administered by Library of Congress, and trademarks and patents, not surprisingly, have laws administered by the U.S. Patent and Trademark Office. And those laws, of course, are laws that Congress passed in order to carry out the power that it was given in the Constitution. But we want to emphasize here, as John sort of separated copyrights, trademarks, and patents from trade secrets, and the separation is in how is administration of the law versus enforcement of the law. There is no federal agency that administers any laws with regard to trade secrets. All of trade secret law or that kind of thing happens as an enforcement on the enforcement side. There are also enforcement sides to copyrights, trademarks, and patents. Those happen in court, and sometimes they're almost the more interesting part of the whole patent, trademark, copyright arena. Your property is really only as valuable as your ability to enforce your rights. So sometimes we like to use the analogy with intellectual property. It's real property. It can be bought, it can be sold, it can be inherited, all of that. And we like to use the analogy sometimes to think of it as real estate. So if you think of your property, if you had a piece of real estate, let's say 10 acres, and suddenly someone came along and said, you know what, I like that little 1 acre northwest corner of your property, and I'm just going to go ahead and build a house on it. So you could consider that sort of copyright infringement or trademark or patent infringement. Now, the real estate analogy doesn't exactly hold, because if someone did that with your land, you could call the police and say there's a trespasser and get them off. Your intellectual property, there's no police that you can call. What you do instead is go to court, and you have to defend and say, hey, that 1 acre is part of my property, and I want them out of here. And if you aren't able to enforce that in court, then your intellectual property isn't really worth very much. So it gets real interesting in the enforcement arena, but that's separate from our function.
That's right, and those are gone through the courts. In fact, the President and Congress set up a special court in 1982 called the Court of Appeals for the Federal Circuit. That we called the CAFC, and that is supposed, or was supposed to have been, the Supreme Court for all patent cases. But the Supreme Court has recently stepped in and overthrown a number of rulings by the Federal Circuit. So, and we'll talk a little bit about one of those as we get into another slide or another presentation portion. Yes?
John, I think Mindy and you both referred to a slide that would explain these issues. Are we supposed to be seeing a slide, or are you referring to what you'll send later?
I'm going to send those later. I should have sent them this morning. I got bogged down on something else and I didn't get them sent to you. And I apologize for that. Okay?
Just had to make sure that we weren't missing something we were supposed to be seeing on the screen.
No. Well, you should be seeing it, but there's no way to show it on our screen unless we have it in front of us and show it that way.
Yeah, and we're using the slides to help guide our conversation with you. And I don't think there's not that much information on the slides. This one just lists the 4 types of intellectual property. So you're not really missing that much. It's just more like how we stay on track. And we'll try not to refer to the phantom slides that don't exist anywhere.
That's right. Okay, what we'd like to talk about now are copyrights and bring forth what they really are. And I'm going to start out by asking a simple question. How many of you have a copyright? Put your hand up if you have a copyright.
So everyone should raise their hand.
Put your hand up. Okay, and really everything that you've ever done, that you've written by yourself for a school assignment, every time you took art as a kindergarten person and made that. I like to tell everybody I have a train, a picture of a train in front of my desk that my granddaughter drew when she was in preschool, and it's 2 cars and an engine. And the 2 cars each have 3 wheels on them, and the engine doesn't have any. It's the maglev train. So it's definitely a piece of art that is
original.
It's original, and she has her name in the border, Natalie, so I know that she did it. I don't know when, but she did it. And even though it's not a registered piece of art, it's copyrighted. Okay?
And remember, copyright is subject to Article 1, Section 8, Clause 8, which you couldn't see on our first slide, that says limited times and exclusive rights.
Right.
So here the exclusive right really is, as copyright says, who gets to copy it. So the question is, can Natalie actually copy it herself, or does she just get to exclude others from copying it?
She just gets to exclude others from copying it. So she can copy it herself, but she really excludes others from copying it. That's really the exclusive right.
Yeah, so under what circumstance would she be unable to copy it herself?
If she gave it to someone else or sold it to someone else, or it does not become her property.
Or, let's say Natalie was a brilliant artist and actually was able to put a copy of the Mona Lisa on her train. Would she be able to copy it then?
No.
No. And that's because by copying it herself, she would be violating someone else's copyright, because she has someone else's work embedded within her work. So that's why Congress, or the Constitution, gives the exclusive right. It gives the right to exclude others, not the right to do something.
That's right. Now that term, that exclusive term, or the term of length, is a little different in copyrights than it is in patents or trademarks. And remember, trademarks is one of those that doesn't have the exclusive, the limited term. In copyrights, it's the author's life plus 70 years. Now, up until 1998, it was 50 years. But in
Author's life plus 50
the
years.
author's
Yeah.
life plus 50 years, excuse me. In 1998, Sonny Bono introduced, and a bill was
How
passed.
many of you do remember Sonny Bono, just like out of curiosity?
How many knows Cher?
Sonny and Cher.
Yeah, that's the other half,
there you
yeah.
go.
Yeah, okay, it's the other half, Cher. Anyway, Sonny Bono was a congressman from California. He introduced a bill called the Millennium Copyright Extension Act. And it really, I like to tell people that it protected an American icon. It really gave a 20-year extension on the works of Walt Disney. So Mickey Mouse, Pluto, Donald Duck were all covered for an additional 20 years. So now from Walt Disney's death until that 70-year term is over, Walt Disney Corporation has the exclusive rights to all of his work. What happens at the end of the 70 years? It becomes, at this point in time, it becomes public domain and anybody can use those images. However, anything can happen in Congress.
It can and frequently does. And it'll be interesting to see what happens after we get to the end of the extension, because I suspect Walt Disney Corporation isn't going to willingly give up the copyright to such lucrative cartoons and characters, and whether they'll lobby Congress and whether they'll be successful and whether that will be challenged in court are all some interesting questions, because again, the Founding Fathers' intention was that these things be covered only for a limited time. Remember, what we're doing is giving people a monopoly, and in this country we don't generally like monopolies. The government breaks them up, or the government looks at whether companies can merge and whether that would form a monopoly. And we just don't like monopolies in this country. Our system is not one that favors them. And this is a government-sanctioned monopoly. So, the Founding Fathers said, well, it's worth it in order to get this stuff out into the public domain after we give whoever created it some exclusive right for that limited time. So it'll be interesting. It's an interesting question to think about, and hopefully at some point in the future, if Congress takes up the issue, you all will remember being in this class and thinking about what would happen if it came before them again.
You have to get another 20 years on top of the 70.
Yeah.
Okay, now let me tell you that there's a lot of things that are covered by copyrights. Those things that we write, definitely covered by copyrights. Those things that we draw, photographs are covered by copyrights. But soup labels, the label on the back of this soup can, or on what's on a Coca-Cola bottle, that plus anything that's written can be copyrighted for that company. So it's covered. It gives you kind of a significant holding so that others can't copy exactly what you have. A couple other interesting areas of copyrights are that of computer programs are copyrightable. The computer chip, the design of the computer chip is copyrightable. And if you come up with a new boat hull, it is also copyrightable. It's the design, it's the architectural rendering or the architectural input that you see, or the look of that boat hull is considered art, and therefore it is covered under a copyright. Interesting things. Okay. The next area that we're going to talk about, before we get to that, let me ask, anybody have any questions on copyrights? Yes.
So, for example, Campbell's soup labels are copyrighted. How does someone like Andy Warhol create it? Make all those screens?
Say again.
How does someone like Andy Warhol make all those screens?
Well, that was a rendition of the copyright or of the Campbell soup, and he was just, taking a liberal interpretation of it as an artistic endeavor. It doesn't cover what it. He's not trying to sell the soup. He's not trying to sell all that. But if you look on it, it is the written word. It's the instructions of how to use, the instructions of how to do certain things. And that's how he got around it.
It also wasn't an exact copy. And here's the other thing. Remember from our real estate example, if he did do an exact copy and was selling them, and Campbell's didn't take him to court to stop him, he could do that as long as he wanted to. So it's really not up to us. It's not up to the federal government. It's not up to the courts to stop Andy Warhol or somebody who does something like that. It's actually up to Campbell's soup to say, that's our property, you're using it and we didn't give you permission and we want you to stop. And they could also come to and we don't know the facts, right? But it's possible that they did sell him that. And he said, well, hey, I'll pay you some money and let me keep doing this. Okay? But that's a great question.
There's a lot of things that can go around here. I mean, it could happen. And he could, as Mindy said, he could have paid the royalty to Campbell Soup to make that picture or that painting that he's done. Okay? Let's go to trademarks.
Yeah, so
As we-
trademarks.
Yeah. As we said, trademarks are one of those really quirky things that doesn't have a time limit. I'm going to come back to that in a minute, but what a trademark is any name, word, symbol, sound.
Fragrance.
Yeah, she's like to say that word.
Fragrance.
Fragrance. Even colors are trademark. And you'll see motion. How many have ever seen the RKO tower with the flashes of light going away from it, or the roaring lion from MGM? Not only is the sound trademark, but the motion with the sound itself is a trademark. We've got UPS, the brown of UPS, the pink of Mary Kay, the pink for Owens Corning fiberglass. Those are trademarks. So we got a lot of different things. In fact, I have on my display that I'll send you is a picture of Coca-Cola and the bottle. Now, the real interesting thing is that the bottle shape is the second oldest shape trademark. The oldest one is no longer in existence because the company went out of business, but it was for a bottle for holding olive oil. It was an olive oil bottle. But Coca-Cola is the second oldest shape trademark. A little piece of trivia here.
Yeah, well, and speaking of trivia, let's sort of think back as to how and when trademark law really developed. Trademark law gives the consuming public some certainty of the source of a good or service. And there have been various times in our history, including last fall, about this time, I think, last fall, when there have been products on the market that were injurious to the public. And so people in those times become really interested in where something is from that they're about to eat, especially. So the example I'm referring to from last fall was the peanuts that came from a factory in one of the southern states. I think it was Georgia. And a number of people, I believe, died from eating the products made with peanut paste that came from that particular factory. And quite a few people were made ill. So, I remember that there was a time that last fall, people were looking really hard at vending machines to see, okay, well, what am I going to pick here? And is there any peanut product from that plant before I take that and eat it? So trademark law really does give people certainty of the source of a good or a service.
That's right.
Yep.
Now, we had the Campbell soup can up earlier, but if you look, I got to find out where the center of the thing. Everything's backwards on the screen to me, so I have to figure out where the things go.
Yeah.
But the Campbell soup can has the registered trademark on there. That's the Campbell's. That's one of the items. I'm sure you've all seen this one, the green seal on the cup of coffee. Everybody know what that one is, I'm sure. Most of us are addicted to it. But that's the Starbucks label, and you can go anywhere in the world and you know you're going to get the same type of coffee wherever it is. It's going to taste the same from a Starbucks. Another option is on the side of this helmet there is a Steelers label, the Pittsburgh Steelers. I'm not a Pittsburgh Steelers fan. It was given to me as a gift by the Pittsburgh Intellectual Property Law Association when I talked to them one time. It's a great item to talk about. But the Pittsburgh Steelers have identity. This is a service mark because we don't buy Pittsburgh Steelers, right? What we do is we buy products that identify the service that they provide, which is a game, entertainment.
Yeah.
So, and the other thing, there's a big one on the back of this, and you can't see it, but there's this little funky label back here, which is the NFL label. So we know this is an NFL sanctioned item. Another one we have, which is kind of neat, is this. Have you ever seen a Cracker Jack can? That has been around. It's kind of interesting because it has here on the side of it, it says UK trademark registered September 18th, 1897. So Cracker Jacks has been around for quite a long time. again, it talks about that longevity. And the last one I bring up is our favorite, the Coca-Cola label. This is actually from a wooden box that used to hold those plastic bottles. You remember those things, Eric? Yeah. Not the plastic bottles, but the glass bottles, right, the old glass bottles. Now, the thing about this is this label has been around since 1787, so, or not 1787, 1897, as has the Cracker Jack. So it's one of the older labels that we have. And why can you continue to have them, as it said in the Constitution? There's no time limit.
Yeah, it's subject to Article 1, Section 8, Clause 3, which has no prohibition on the time.
Now, there is two things that will keep, well, actually three things that will keep you from getting continuous use of your trademark. One is if your company goes out of business and you stop selling, stop selling your brand, then you're not using it in commerce anymore. So that's one way to lose it. Another way is to basically let it go or become, we call it
Generic.
generic. Couldn't even think of
Yeah.
it.
Well, so like let's talk about what generic means, right? So I'm going to give you two things, and you guys can guess which is generic. Facial tissue, Kleenex. Any guesses? How about photocopy, Xerox? Right? How about moving stairs, escalator?
Bet you didn't know that.
Yeah, I actually, when I first started giving this talk, I didn't know that either, and I said, wait, I thought escalator was the generic term. But, the thing is that for companies, it's sort of a double-edged sword. They really want their name to get into the vernacular. They sort of like it that people walk up to a photocopy machine and say, I'm in a Xerox, doesn't matter what the brand is. And yet, it does matter, and they do care because they could lose their trademark if it really gets into the vernacular. Escalator was actually a brand name, and moving stairs was the generic term or generic name for what an escalator was. But escalator did not protect its trademark from becoming generic, and so now they no longer have that trademark. And when we give this talk, we frequently talk about facial tissue. We actually don't walk up to each other and say, do you have a facial tissue? We say, do you have a Kleenex? And then we get whatever we get. It could be a Scott tissue, it could be a Puffs or a Puffs Plus. And I don't hand it back and say, no, I asked for a Kleenex and you gave me a Puffs Plus. I take whatever I get. And that's how something becomes generic.
That's right. The way companies go about protecting that is two ways. One, the company can have somebody or one of their attorneys send out a letter to you saying you are improperly using our term in something that you're selling or something that you're writing. How do I know that? I got one of those type of letters when I was an examiner because I was using the Velcro name in exchange for hook and loop fastener material. Or they can do it like Xerox does, and they have TV commercials, radio commercials, print ads that says you can only get a Xerox copy from a Xerox machine made by the Xerox Corporation to enforce that fact that it is a trademark, and that's the way they keep it. But there's one, and we talked about generic, that may become generic if it doesn't watch out. It's a very popular term, and I know you all use it every day. When you search on the internet, what is the first thing you do? You use something it. Yeah, that's it. It's exactly right. And Google is a trademark. It's become so popular now, it is actually in the dictionary as a term for searching on the internet. So what's going to happen when they come back in here to get a renewal? I can't answer that.
Yeah, now here's something to think about too. John said that he got a letter for, what term did you misuse?
Velcro.
Yeah, he got a letter for misusing Velcro. And, but we don't want to leave you with the impression that if you all say Google or, ask somebody for a Kleenex and take a Puffs Plus, you're going to get a letter. He got that because he misused that in official government, federal government correspondence. And the company became aware of that. Of course, they can't allow the federal government to misuse their trademark, because it sort of gives it even more emphasis. If the federal government is doing it, it makes it seem like it's okay. So there's no police that will come to your dorm and make sure you're asking for a Puffs Plus when you really want a Puffs Plus or anything like that. But there are people, Coca-Cola actually sends, I don't know if you call them spies or I don't know what you would call them.
Secret buyers.
Secret shoppers to restaurants to ask for a Coke. And if they get a Pepsi and the restaurant didn't say, or the waiter or waitress didn't say to them, we only have Pepsi products, is a Pepsi okay? And they just serve it after the person asks for a Coke, the restaurant will get a cease and desist letter. So they do have people out there looking to make sure.
Right. Another thing that, I talked about the pink for Mary Kay and the pink for Owens Corning fiberglass, the colors. It's just an illustration of what happens. There are 24 classes of goods and services that we issue trademarks in. And when you get a trademark, you would designate which class that you want to be protected in. Coca-Cola has, I don't know how many different classes that they've got that covered in, because they sponsor race cars and they have it on shirts and a whole bunch of different things. So they're covered in a lot of different areas. And I bring that up because you wouldn't want to use Mary Kay Cosmetics as the insulation in the wall of your house, nor would you want to use the pink Owens Corning fiberglass in place of the Mary Kay Cosmetics on your face. So, they're pretty easy to understand the difference between the two.
Well, and if you think of it too, remember, the whole point of trademarks is to be able to identify the source of a good or service. So if you saw someone carrying a pink cosmetic case and they just stepped out of a pink car, you wouldn't say to yourself, gosh, I wonder if they're from Mary Kay or Owens Corning.
That's right.
You would know they were from Mary Kay, or you wouldn't know.
Yeah.
And similarly, if you saw pink insulation on a house, you wouldn't say, well, who made that? Was it Owens Corning or Mary Kay? You'd either know it was Owens Corning, or you just wouldn't know. So it's important that there's no confusion in the marketplace with a trademark that's already in effect, because you could actually end up damaging the company that has the first trademark. So let's say John was going to start a delivery service and decided he really liked the color brown. It's his favorite color. And he knows UPS has brown, but he feels like that's a dark chocolate brown, and he's going to go with milk chocolate brown.
Right.
They're different colors. However, John's delivery service stinks. He either doesn't deliver the packages at all, or he delivers them late.
They actually go in my garage.
They do, and then he sells them on eBay. Now, if you saw John in his milk chocolate uniform get out of his milk chocolate truck, and you couldn't see the label on the shirt that said John's Delivery Company, and you saw him heaving the package up on somebody's porch and you hear it shatter, would you think that it was UPS? You probably would. You'd just see brown and delivery and boxes, and you'd think, what the heck happened with UPS's service? I'm not using them anymore. So companies really do jealously protect their trademarks from damage by others.
That's right. Let's give you a real example. There was a company that formed somewhere around the early 1960s. It's a record company. And they got a trademark for a piece of fruit. That was their trademark. It was an apple. Anybody know who owned the Apple record company? Yeah.
Was it the Beatles?
That's exactly right. It was the Beatles record company, the Apple Records. Well, I had a trademark back in 1960 something, early 60s, and a few years later there was another company called Apple Computers. They got another trademark for the Apple, the same shape, little bite out of the corner of it, but Apple Computers. They're in different segments and different industries. So they have two different, the same trademark, but for two different things, similar to Mary Kay and Owens Corning. But in the early 2000s, I think, they came out with this little device that I bet you every one of you have. You walk
Or you've heard of it.
Or you walk around with these things sticking in your ear, like Michael Phelps does before he goes up into his, gets up there and breaks all the world records, he's listening to his iPod. But what's happening? That's an Apple product. Now, what do they start selling to come into that? What was it? What was the thing they put on the internet where you could buy music? iTunes. Now, what business are they in? They're in the record business essentially. So now, is there a discrepancy between the two of them? You remember, Apple Computers is a computer company. Apple Records is a record company, but now Apple Computer is in a selling of records. So is there a confusion of which one they are? And the courts basically said, yes, there's a confusion. So today, Apple Computers is paying a royalty to Apple Records to continue to use the Apple label with their iTunes. Just a little bit of trivia so you can find out how it goes about in court. And it kind of answers your question earlier about, the paintings with the Campbell Soup label, Andy Warhol. Same idea.
Yeah, and there's one more way that you could lose your trademark, or actually not get your trademark registered at all, and that's if your trademark is publicly offensive. So we don't give examples of things that could be considered publicly offensive for obvious reasons. But our example of that has to do with our football team. So our football team is the Washington Redskins, and some people think the way they play is publicly offensive, I guess. But when their trademark last came up for renewal, there was a public protest based on the use of the word Redskin in that context. And a Native American group protested, saying it was publicly offensive. And the trademark was actually renewed within the office, and the Native American group has taken that forward, and I believe it's going to court this fall for some sort of final disposition. But that's an example of the kind of inquiry that happens. Something might be publicly offensive to one group and not to another, so that can sometimes be in the eye of the beholder. But if it's clearly publicly offensive, you won't get the trademark.
I want to go back to copyright for a second, and then I'll come right back and talk about trademarks in the same sense. In a copyright, you'll see a Circle C. That means it's a registered copyright, registered with the U.S. Copyright Office or the Library of Congress. In a trademark, you may see a TM on something, or you may see a Circle R. The TM means that the people that are using that as a mark intend to use it as a trademark, although it has not been federally registered. There may be instances where they cannot get a federal registration, but they only register in the state, because each state has their own trademark office. So it may be a state trademark, because one of the reasons they couldn't get it is because it's not sold across, the services aren't sold across state lines. So you may have a company.
Well, let's just draw you back to that first conversation we had about Article 1, Section 8, Clause 3, that gave Congress the power to regulate commerce among the several states. So Congress has no power to regulate commerce that happens within a single state, and therefore, if you were to do commerce only within a single state, you would go to that state trademark office to register your trademark.
And my example is, let's say you have Joe's Plumbing in Providence, and it doesn't go anywhere else but in Providence. So he might have a trademark for a plumbing, or pipe wrench with a drip falling off of it, and it says Joe's Plumbing, and that may be a state trademark, and it would say TM behind it. The Circle R means that you're selling the goods and services, or offering the goods and services across state lines. And today, that means if you offer it on the internet and be able to sell it on the internet, you really cross state lines in that respect. So that's what you have to do. And that is a Circle R once you get a federal registration. Any questions on that? Yes.
It's tempting to, of course, ask about the use of your delivery service, Brown. I hope there's no confusion with where we sit here. Seriously, is there an issue about actual use of trademark? In other words, you can trademark something and never use it, or how does that work?
No, you have to use the trademark. Now, you have to prove it's being sold you have to give examples that it's being so,
You can actually, well, right, you could actually apply to have it registered before you're using it in commerce, but you have to say that you intend to use it in commerce, and you have a limited period of time to show that you started using it in commerce, or you'll lose
Yeah,
it.
you have 3 years from the time it's been approved to show that it's actually been used in commerce. You get a 6-month, and you can renew, 6-month time period to show that it's being used, and you can renew that for 5 6-month periods, and after that, you lose the mark.
And that's called an intent to use
Yeah.
application.
Okay? Let's go on to trade secrets. How many of you know the 11 herbs and spices in Kentucky Fried Chicken? I don't see a rush of hands. Well, that's a trade secret. Or how about the secret ingredient in Coca-Cola? Again, a trade secret. And what we're doing in those instances, or what those companies are doing, is they're keeping something that is secret, not telling anybody about it. And that's clearly what a trade secret is. It's just a secret that you keep from other people. Now, how does that work? Well, yeah.
Is there a question?
Yeah, you might have been going here, but do they have to disclose the secret to you before they can register it?
Yeah, well, so remember earlier in the talk, that's a great question, and earlier in the talk we said that there are federal agencies that administer the laws for everything but trade secrets. And trade secrets are really the responsibility of the secret holder, and they're enforced only through the court, so there's no administration of them with the federal government. The only place that they would need to disclose any part of their secret would be if they have a food, which John's 2 examples, his examples are always about food,
Yeah.
just so you know. And in this case, those 2 examples would likely have been disclosed to the Food and Drug Administration, which does have responsibility to ensure that food products sold in this country are safe. And they would have the authority to ask, okay, well, what the heck is your secret ingredient? And of course, as a federal agent, the people that conduct those kinds of inquiries for food and drug have an obligation to not reveal as well.
Yeah, and trade secrets are, as they say, secrets. So I'll give you an example of how people can protect their trade secrets.
Is this a food example?
No, it's not. I used to work, when I was in graduate school, I did a paper on the textile technology area, and I was doing a study of a plant to try to figure out what was happening in it, and I wanted to get in this company called Chicopee Manufacturing Company, which was right outside of Raleigh, North Carolina, where I went to graduate school. And I called them and asked them if I could come and visit, and I was told flat, no, you can't, you're not an employee of the company, we don't let anybody in. It just happened that the professor that I worked with was on their governing board and as a consultant, and he asked them, and he says, no, you can't even come in with me, to show them around because we are a secret. They're so secret with the process that they do is that they have 2 fences around their property. One that comes around their parking lot for their employees and the building, and another one that's set out another 100 yards or so. And what happens is when you bring a truck of material in, the driver drops the trailer and drives out the main gate, and then one of the employees comes out with what they call a yard bird, hooks up to the trailer, and takes that in to hook it to bring it into the gate. That's how secret they are. That's how they protect their secret. You know, and as a when you go out and work in industry, you're going to sign, we hope, at some point.
Well, we hope you're going to work. Not that
Yeah, we know you're going to work,
sign.
you know, but you'll sign a contract of employment, and if you have a company that you own or run, you're going to have employees sign a contract of employment with you. In that contract of employment, more than likely, you'll have a clause in there that say, I will not divulge trade secrets, or I will not divulge proprietary information. That's that contract between you and the company, and that's where the contract law comes in. If you break that contract, you could go to jail. You're going to lose your job more than likely. And what can happen if the company loses a significant amount of income, you could be responsible for reimbursing the company that income.
Should we tell them a quick example
Yeah.
of somebody who went to jail? So there was a secretary who worked for the vice president of product development at Coca-Cola, and she became a disgruntled employee and decided she was going to take the secret formula and offer it to Pepsi for $6 million. And so she did that. She got the help of her brother and his girlfriend, or her boyfriend and his sister, or something like that. And, Pepsi decided that it wasn't really worth it to them, and they called the FBI, and there was a sting, and that secretary ended up in jail, as did her boyfriend and his sister, or her brother and his girl, whatever.
Whoever it was.
Yeah, whoever it was, but she got relatives involved, and they went to jail too, so it wasn't just her. So companies are pretty serious, because their only recourse is to enforce in court. Remember, if you let somebody build a house on your 1 acre, or 1 acre of your 10 acres, then everybody else can come along and do the same thing. The next person who wants to do it will say, hey, you let that first person do it, and you didn't do anything about it. So companies have to really, really, really take good care.
Now, we're going to go ahead and move on to patents, but before we do, are there any questions on copyrights, trademarks, or trade secrets? Yes, in the back.
Are business plans considered trade secrets? Let's say if someone asked me someone wants to tell me their business plan, but it makes me sign a non-disclosure agreement that I won't reveal what is in the business plan, would that be considered a trade secret?
If that business plan is really part of what makes that business go, yes, it is a trade secret.
Yeah, and you get to say, right, you get to choose what you're going to hold as a secret in terms of making yourself competitive. And you want to just really be careful, because there's a point of demarcation where you can't then switch after you go forward. You can't switch from patents to trade secrets. So the whole point of patents is to get you to disclose to the public. So we're going to talk in just a second about patents. The whole point is to get you to disclose. That's what the whole point of that clause in the Constitution was, so that the public can use that as a building block. Otherwise, everyone would hold everything as a trade secret, which would be like you coming to school, to university the first day of your freshman year, and having your professor say, everything that's been known before is a secret, and we aren't going to tell you. You have to go out and discover it. And then the next year they say the same thing to the freshman class, and the next year and the next year. We really wouldn't make a whole lot of progress in science and the useful arts if that was the way work was conducted. So the point is to get you to disclose. And if you have something that's easily reverse engineered, for sure you do not want to go the trade secret route. What would happen if you did? Somebody would buy one, and they'd reverse engineer it, and they wouldn't need you anymore. So you would actually have no business, no company. So you really need to think very carefully. And for Coca-Cola, they've had a much longer run of that product than they would have had if they had just gone the patent route. Because it's been in effect for how long, did you say?
Over 110 years.
Over 110 years. So they wouldn't have gotten a patent for that long a period if they had gone the patent route. So you just really need to be thinking about that.
Okay, now, I'm going to go ahead and start with the patents. The U.S. patent system is a quid pro quo system. It means that you give us something and we give you something in return. And that's the power to exclude others from using your invention. That's what you get if you give us information. And that's exactly what's set up in the Article 1, Section 8, Clause 8. Now, what we ask you to do as an inventor is we ask you to give us enough information so we can share with the rest of the world what your invention is. Because what happens is, if we give that information out, then other people can see where that technology is moving and make improvements on that technology or take it to the next step. So that's why we want to do it, and that's the progress of science. That's the progress of the invention arts. And we give you the exclusive rights to that invention for that limited period of time. In other words, we grant you a limited monopoly. Something funny for the government to do, isn't it?
Yeah.
Okay.
Okay, great. So what exactly is a patent anyway? It's a funny name. And the patent system as we know it actually is quite old. It was first known, or we first know of it as being in existence in Venice in the 1500s or the 15th century, around about that time. Same thing. And at that time, actually, the patent term was 14 years in Venice, which was twice the length of indentured servitude. And I haven't been able to find out why it was twice the length of indentured servitude, but there was a connection there. So in any case, what the patent grant is, it's a grant by the federal government that gives you the right, remember it's an exclusive right, so it gives you the right to exclude others from making, selling, or offering for sale, using, or importing your invention. And again, it doesn't give you the right to practice your invention. As John just said, much of what we see come through the office, the patent applications we see come through the office, are improvements over something else that may already have a patent. And the patent for that something else may still be in force. So if you improve something that John invented, and John has a patent that's still in force, the government isn't going to give you the right to practice your invention, because you would be then violating John's exclusive right for his invention. And the government's not going to give you the right to infringe on somebody else's right.
Yeah. And let's give you an example of what happens when somebody does infringe. I like to use this invention because it's got a lot of money value in it.
Yeah, I like this one too.
There's an inventor out in the West Coast. He happens to be an orthopedic surgeon, and he did every time he went in to do a back surgery, he found out he didn't have the proper bone spacer or bone, piece of material to hold it together. We call them bone appliances in the art here. But what he did is he invented a whole bunch of those and got somewhere in the neighborhood of 30 patents. And he was selling a few of his inventions, a few of these things, and he was manufacturing them. He was being fairly successful. He was a very successful surgeon. And one day he noticed that there was another company selling similar type bone appliances. And that other company happened to be Medtronic, which is a very large medical manufacturing company in the United States. And he did the smart thing. He went to see his attorney, and his attorney went to Medtronic and said, "Hey, we're going to sue you. You're infringing on my client's rights here." And what they ended up doing is the two parties came together before they got to court, and they agreed in principle that Medtronic would buy the rights to all those patents because they had good commercial value. They would hire the surgeon as a consultant for a period of 10 years, and they would pay him $123 million a year for 10 years. So, a little mistake that they made. It was only a $1.23 billion mistake. But that's the value that happened in this situation, and you get the understanding that he actually worked his exclusive rights to the best of his advantage.
Yeah, and remember exactly that your patent is really only as valuable as your ability to enforce your patent. So if he had been unable to do that, he would have in effect lost, $1.23 billion over the 10-year period. And companies actually make strategic decisions about infringement. Now, there's a couple types of infringement. The court would consider willful infringement versus infringement. You may not have known that you were infringing, or you may have actually purposefully infringed. You may have known about a patent, and you may have said to yourself, heck, you know what, it's going to cost me less to just go ahead and infringe than to license it. I don't want to pay $1.23 billion. I don't have that. I'm going to go ahead and infringe, and I'm going to take my chances. And when I get to court, what I'm going to do is I'm going to attack the validity of that patent, and I'm going to say, that patent's not valid, and here's why. And I'm going to hope for the best and think that spending money on the attorneys is cheaper than infringement. So if Medtronic had taken that tack, that surgeon wouldn't have had something that was worth $1.23 billion. He would have had something that was worth significantly less.
A lot less, yeah. Now, there are three types of patents that we deal with in the U.S. patent system. I'm going to start with the easiest to understand. That is a plant patent. A plant patent is for plants that are asexually reproduced. Those are things like the different color rose, petal, the roses, or it could be a different type of ornamental leaf. Camellia has a different color. Those are the type of things that we get in. We only have a couple examiners that do plant patents, and they are actually looking at the coloration. And that's what they get the patent on. What does it actually look like? What is the color? So that's fairly simple to understand. It's part of the utility area. It gets the same term as the utility.
Yep. And actually, if you ever visit our campus, we have sort of a quad arrangement, and out in our quad is almost a living museum of plant patents. So we have a number of plants out there, and there's plaques that say what the plant patent number is. So it's kind of an interesting display.
Right.
Yeah.
And the next one is a design patent. And we hear, students talking about taking engineering design courses. Well, the engineering design you're doing is actually making something work rather than what it looks like. A design patent covers what things look like. Now, I've got two coffee mugs in front of me, and I picked both of them that have a little bit of silver on them. Now, both of them have the same function. They hold coffee, and they keep it warm for a period of time. So when I walk around the corner to Starbucks, I can take my mug here, and I can get it refilled, and by the time I get back to my office, it's still hot. And it'll stay that way on my desk for a period of time, and I can still use it. Now, this one works the same way. But what's the difference between the two? It's between what they look like. This one's got almost a straight cylindrical shape, and this one has an hourglass type shape, plus it has something in the inside here, a little bit of plastic or rubber that keeps you from burning your hand, just in case. And it actually gives you a little bit something to hold on to while you're walking. So even though it has a function, it does have a difference in shape. They both do the same thing, but they look different, and therefore you get a design patent on the difference in look. A design patent has a term of 14 years from the date of issue. 14 years from the date of issue. Okay? We'll talk about utility.
Yeah, so the last type of the last type of patents that we're going to talk about is utility patents. Utility patents are pretty much exactly what it sounds like. They're patents for things that have utility. It's about the functional nature. So, John mentioned that this looks different than the other coffee mug, and there is actually a functional component to the design. So this area of the cup might have been the subject of a utility patent because it is tied to a function. So design patents that are to things that have no relation to the function of the item, and utility patents are related to things that do have function.
And these are the two lids. I just want to show you, this is my cup. And the reason I have my cup is because it's got a closure, because the slob that I am, I would spill it all over my tie before I got it back to the office. So I have to close the top so that it doesn't spill.
That's why he's wearing a coffee-colored tie today.
That's right. So, you can't tell the difference if I did spill it. And the other one has got a couple holes in it that allows, to sip more coffee through. Plus, it's got a hole at the bottom that allows the air to go in so it'll flow freely. And that's not a good one for me to use because it would be all over me before I got back to the office. But those are different. They are functionality, and therefore they could be used for utility patents. Now, a utility patent is anything that's new and useful process, a machine, an article of manufacture, composition of matter, or any improvement on those. Again, it's new and useful processes, machines, articles of manufacture, or compositions of matter. And this is basically from the statutes that tell you what you can get a patent for.
Yeah, so remember Congress was given the power to promote the progress of science and the useful arts, and Congress exercises all their power by passing laws. So they passed a number of laws, quite a few laws, that say, here's the circumstances under which you can get a patent. And one thing I want to add is a lot of the applications that we see are directed to new uses for old things. and you can get a patent on a new use for an old thing, even though you can't get another patent on the, or a patent on the old thing. Which brings us to what you can't get a patent on. So you can't get a patent on things that are not new. We say things that lack novelty. And that's because we would be then taking out of the public domain something that was already in the public domain, and that would really cause a lot of economic instability. Imagine if we were today, well, today's not Tuesday, right? So on Tuesday, we grant patents on Tuesday. We issue patents every Tuesday at noon. Okay, a new crop of patents come out. So let's say this coming Tuesday at noon, we issue a patent to aspirin. Now remember what we said you get if you are the holder of a patent. So if you're the holder of a patent to aspirin, you'd be able to exclude others from making, using, selling, and importing your aspirin. Therefore, you would be able to walk around to every manufacturing plant in this country, every store that sold aspirin, and you could say, stop, you don't get to do it anymore. That would really cause a lot of market instability. So it has to be new. We don't take out of the public domain that which is already there.
That's right. Another thing that in the newness is what we say it has to be, if it's made public more than a year before you file for a patent, you can't get a patent. So let's say as a college student, you do a project in one of your classes. And all your classmates haven't seen it, but you make a presentation to them. That's a public disclosure. You have a 1-year time frame within which to file for a patent of some sort within the patent office. You also have, since it's made public, you basically are not going to be able to get a patent anywhere else in the world, a few other places, but most of the rest of the world has a strict sense of novelty, a strict sense of newness. So if you make a public disclosure before you file, you can't get a patent there. That's the French for you. They're the ones that started that.
Yeah. Well, and so this is particularly relevant. You know, John just used an example of your student. And if you go on after you graduate, if you become a professor, it's particularly relevant to you. I was a graduate student. I have a PhD in biophysical inorganic chemistry. Well, you can imagine my professor, my graduate advisor, liked to go to meetings, National Society or American, whatever she went to, and she liked to talk. Now, do you think she liked to talk about the things that we did, you know, last year that she'd already published or filed an application on, or the things that we did last week that seemed kind of new and different and a little bit exciting? Pretty much the things that we did last week that there was no application filed for, and she talked and talked and talked. Now you have a certain amount of leeway because sometimes inventions need to be developed and it's not really your invention yet. But this is a good place to talk about. Sometimes you want to really consult a professional. I don't know if these commercials are on anymore, but there was a commercial, I think it was last year anyway, you would see it all the time, it was a financial institution. And there was a man sitting at his kitchen table, he was on the phone, the surgeon was on the other end of the phone, he was holding a knife, and the surgeon says, insert the knife between your third and fourth rib. And the guy on the phone says, shouldn't you be here doing this for me? And the punchline for the ad was sometimes you want an expert. And sometimes you also want an expert to talk about your patent issues when they become a little bit complicated.
That's exactly right. So it's good to consult someone if you think you have something that might be patentable. Another thing that can't be patented is something that is an obvious variation of something that's already existing. Okay, I have a red wagon, and Mindy says, well, I'm going to get a patent on the wagon I just painted green. Well, that's an obvious variation. It doesn't change the function of it. So it's just not something that can be patented. In fact, the court case, remember we were talking about how the court has stepped up recently. The court case that is so important right now in the obviousness standard is what we call KSR versus Teleflex. If you are into or want to look into any kind of patent law, that would be an excellent thing to look at.
Yeah.
It will take you all semester to read it and to take it apart and figure out what it really means. I've read through it 3 times, including all the other related cases that are in it, and it is a bear. But it really tells you what it means. In fact, what the thing was in the case was a automatic adjusting foot pedal in a car. They already had a mechanical adjusting foot pedal in the car, and there were other things that were automatically adjusting. but they couldn't put them together because a lower court said that it had to have a teaching, a suggestion, or a motivation to bring two pieces of technology together, two pieces of prior published patents.
So who John is referring to in that they couldn't put them together means the patent examiner
Right.
couldn't put them together to say, I found all these elements, even though they're in different references, I found all the elements, and therefore I'm going to say that your invention would have been obvious.
Right. So what the Supreme Court said is, no, it doesn't have to have a teaching, suggestion, or motivation. It has to deal with a level of skill of the person in that technology and their ability to view a change that should happen or could happen. It's really laid out a lot of what is should and what is could, type of thing. Another area that we have to make sure is your application, if you don't have a utility for it, you can't get a patent.
A utility patent. You can't get a utility patent.
That's right. So if there's no utility, if it's a bucket that's supposed to hold water and there's no bottom in it, you can't get a patent on that. We have a very low standard of utility. All we want to know is if it works for one person, then it has utility. It's useful to that person.
Yeah, so another thing that can't be patented are inventions that are not clear, things that are incomprehensible. Remember, John talked about the quid pro quo, the this for that in the patent realm. So the this for that is that you have to tell us in sufficient detail how to practice your invention such that the public would be able to do that after the expiration of your patent and once the invention is in the public domain. And the examiner also has to make a determination as to whether or not your invention is new and non-obvious and has utility. And if your application or your invention is not clear or it's incomprehensible, the public would not be able to enjoy what is its right after the expiration of the patent, nor would the examiner really be able to even make the determination as to whether or not your invention is patentable.
Something else that you can't get a patent on is our pure mathematical expressions. Those are things like a computer program. That's a mathematical expression. A computer program per se is copyrightable. And at this point in time, there is a court case a case that's going to go to the Supreme Court and be heard this fall that may determine whether computer programs are patentable at all. So we don't know where to go with that one. I'll just leave it saying that the pure mathematical expressions are not patentable. And finally, things that don't work aren't patentable. So if you're figuring out how to make that perpetual motion machine in your and it requires a 9-volt battery, don't bring it to us, because it won't work. Or that cold fusion. If you can really make cold fusion work, we'll talk to you, but you got to show us it works.
We used to like to say cold fusion was a hot area in the mid-90s.
Anybody have any questions before we move on? Yes.
One question is about the differences between trademarks and design patents. You had said you could trademark a shape. Is that a two-dimensional shape, or wouldn't that be similar to a design patent if it was a three-dimensional shape?
Yeah, a design patent and a trademark can be three-dimensional or two-dimensional. The thing that is interesting here is the trademark is only an indication of the goods or services that you're selling. So if you're selling like the Super Soaker, I'm just picking one out of the hat here, or a Coca-Cola, because it does have a three-dimensional shape. We're not selling the bottle. What we're selling there is what's inside, the goods that we're selling, so it's identified by the shape. But the bottle itself could have a design patent for the shape of the bottle. So that's the difference between the two.
Yeah, and remember what the trademark identifies is not so much the product, but it's the source. It's the source of the good or service. So, the Coke bottle could be used by Coca-Cola for more than just Coke. It could be used for Sprite or, any of the other Coke products, because it's the identifier of the source of the good or service, the company.
Now, the next thing we want to cover are what is patented. Really, what is covered in your patent? How many of you have ever seen a patent? Yeah, they're kind of funny looking. They got these pictures on them and this long description, and at the very end, this weird language stuff called claims, right? Okay, well, the claims are what you get your patent on. So if I told you that I had a toy comprising a articulating member in combination with uh, a sound maker and another device, would you think it would be a Snoopy dog that when you pressed it in the middle, it opened its mouth and the noise came out? But that's what it is. I mean, so the weird language defines what the invention is, even though it may look different than what you see.
Yeah.
It's what we call the heart of the patent itself.
It's kind of like the verbal definition of your real estate border. And remember, we're charged here in the office with making sure that you aren't given a patent to something that's not new. So one of the examples that I remember from, we had a 2-week training when we started in the office, so way back in 1989. And one of the examples I remember was they described for us a picture frame that's hinged, and it has a little oval cutout for where the picture goes. Well, that could actually also read on a toilet seat, right? It's the same little oval cutout, different size, but if you just described that much of it, you wouldn't actually be limited to just your invention. You'd be describing the whole realm of toilet seats or that kind of thing. So claim language is really specific, really picky, really particular. And when you get to be a patent examiner, you sort of start driving your friends and family crazy by asking them to be more specific about that, because you want to know exactly what you're talking about.
That's right. My son and daughter yell at me when I start talking patent language anymore. Okay. Now, patents have value. We've already found that out by understanding what that gentleman or that doctor got for his $1.23 billion, but they create assets. Those are things that you can sell, that you can license, that you can use for collateral, for financing. There's a company that I'd like to talk about. It's called Saw Stop. It was for a table saw that actually stopped when you touched the blade. They didn't have the finances to put this into the marketplace, but they had such a good patent and such a good reputation of their showing of what it is. They took their patents to the bank and were able to borrow enough money to start their business. They borrowed $1 million and basically got into the business with the patents as the value for the backing of that loan. That's what you can do with it.
Yeah. Awesome. Well, and another thing that we could talk about the value of a patent. There's an inventor who just won the National Medal of Honor. His name is Forrest Bird, and I think he must be 90 or late 80s.
Late 80s.
He's such an impressive, wonderful person. If you ever have the pleasure of meeting him, which we both did. But Forrest Bird was a pilot during World War II, and out of that experience, he started inventing respirators. Because, of course, during World War II, when they would fly, they could only fly below a certain height because, pilots would lose consciousness if they went too high and the air was too thin. So he started, and of course, flying lower, you're more in the line of fire when you're flying planes in a war. So he started inventing respirators, and he would take the money that he got from selling his early respirators and he folded it back into research and development. And ultimately he invented what's known as the baby bird respirator, which is still used on premature babies in this country, and it's really responsible for saving the lives of countless premature babies. And, I'm always mindful when I talk to groups of university students that somebody in the room could actually have been one of the people whose life was saved by the baby bird respirator, because before that happened, before he invented that, a lot of premature babies died because they couldn't breathe. And 60 Minutes, I think it was last year, did a special on him, and they ended up bringing his next door neighbor, 16-year-old boy, over to meet him. And he had actually been on the baby bird respirator. He was premature when he was born, and here he was as a 16-year-old strapping young man. So that's a pretty huge contribution to society, and that's what the founding fathers intended when they said they were giving Congress the power to promote the progress of science and the useful arts.
Yeah, and it's also historical data that we can collect. But how many of you would know that Abraham Lincoln actually got a patent for a device for lowering and raising barges in the Mississippi River so he can get over shoals? He's the only president that has a patent. So it's a kind of interesting little tidbit of information.
Yeah, and there's a number of movie stars that have patents. Who was it that, was it Hedy Lamarr?
Hedy Lamarr, yeah.
Who got a patent during the Second World War for some reader or
No, actually, it was
encryption?
encryption code.
Yeah, encryption.
And you know, and there's even a patent on the shoes that Michael Jackson wears when he, you know, does whatever or wore, you know, when he leaned all the way
When
forward.
he did the moonwalk,
Or not
he,
moonwalk or whatever it was. Yeah,
whatever it was called, there was actually a clip that hooked into the whatever surface he was on that helped him defy gravity. It looked like he was defying gravity, but his shoe actually helped him catch him.
Now, yes.
Since we're kind of coming up close to the end of our time together, I just wanted to see if you might touch upon a couple more points. Maybe you had this planned already, but how much does it cost? How long does it take?
Okay. We'll touch on those 2 points. We hadn't planned that, but we will do it.
Well, we're planning it now.
We're planning it now. The cost of a patent, it's relatively simple or relatively cheap to get into the system. We have 2 ways of getting in. One is called a provisional application, which is basically a date and time. It's a date stamp on something in the office that gives you a date of conception, or not a date of conception, but a date of reduction to practice of your invention. That is $110 plus the cost of putting the application together. If you use an attorney, that could range anywhere from $3,000 to $20,000, depending on the complexity of your invention.
In all cases, with regard to filing patents and then actually prosecuting them before the office, the bulk of the expense is the attorney fees, if you choose to go with an attorney. And as we said, sometimes you really do want to consult an expert. So our fees are relatively low. We're I think you said we're one of the cheapest patent offices in the world. And we think we're the best patent system. So it's actually a really good value. But if you go with an attorney, that will be where the bulk of your cost comes. And it's interesting, now there's a lot of conversation on Capitol Hill about our fee structure. Our fees don't actually, we're fee funded, by the way, if you didn't know that. We're completely fee funded. We don't draw taxpayer funds from the Treasury like other federal government agencies do. So we can only spend what it is that we take in from users who apply for patents. And there's a lot of conversation right now on Capitol Hill because our fee revenue has really taken a beating, along with people's reduced filing or making decisions to abandon applications that they filed but no longer think it's worth it to pursue them. And our fees come all the way along the process. It's not just when you initially file. So there's talk right now of raising user fees in order to recover. I think we are looking at a $200 million deficit for this year, which is actually quite a bit of money.
That's why we're not in Providence today.
That's why we're here and not
That's why
there.
we're here and not there. How's that? Yeah.
Yeah, so and that's also why we're not hiring right now. So to your second point, how long does it take? Well, it takes longer or shorter depending on what area of the office you file your patent in. It can range from, maybe 6 months to be picked up for your first office action, a first look at your application by an examiner, to up to 4 years in some of the areas where there's the biggest backlog, like business methods.
Business methods.
And so there was somebody who asked about a business plan. Well, that might fall under the business methods area, and that could be 4 years till we even look at it the first time. And then it would take, it could take a good couple of years after that.
Or even longer, depending on what happens in the prosecution of it. You've got to remember that what happens in the patent prosecution is that an examiner, you will file an application, the examiner looks at it, he or she will take a look and find everything they can that's closely related to it, and then make a legalistic decision whether it's patentable or not. You go back and forth. They'll send that information to you, then you come back with an amendment to it, and it's back and forth until we finally come to an agreement. I can tell you a couple little statistics. We had 440,000 applications filed last year, almost 450,000, and and we also examined almost the same number that we came in, so it was almost a break even last year. But we only issued about 43% of the applications that we examined really became patent, about 43%. So
And that number changes. If you look, I think there was probably something on our website that shows, allowance rates by year, and it's sometimes as high as, 70%, and it's gone down a little bit lower. But right now, we're at a historically low allowance rate, and it is notable that we examined as many applications last year as came through the door, because we haven't been doing that for the last couple of years. We've been running a deficit also in what we examine versus what comes in the door. So did you say what our backlog was?
770,000 applications today are in backlog that still are waiting to be examined, haven't been looked at yet.
And we think that's job security for us.
Yes.
So.
Yeah, and just on a couple of more points of timing, because I think you said what the design patent term is. I don't know that you've said what the utility patent term is, and what happens, when does the clock start ticking for that term?
That's a good point. The utility patent and plant patents both have the same term. It's 20 years from the date of filing of your first non-provisional application, first regular application. So if you file an application today, your term runs 20 years from today.
If it's issued as a patent.
If it's issued as a patent, not from the date it's issued. However, in the law, there are periods of time that can be added back in if we delay the issuance of your patent. There's certain things that we have to meet, certain time frames that we have to meet in the prosecution or in the examination process. And if we don't meet those, they're added on to the back end. So it could be, if we delay 3 years to get to your application, you might have 18 months added back on before, at the end of it. So you would get 20 years plus 18 months.
Okay, we are now at the end of our officially allotted time for this segment. And I know that there's some people already packing up because they have other obligations, so we can't hold them. But I wanted to thank you for this very insightful and very interesting introduction to the patenting and trademark and copyright process. And we'll then expect to be receiving from you some slides that I'll distribute to the class. Just so you know, they will be receiving an introduction from our library staff regarding searching of patents. And so that part is yet to come. So unless there are any last quick questions, I think we're going to have to draw it to a close at this end.
Okay. Thank you.
Thank you.